After several hearings televised for the first time, the Supreme Court of Pakistan has decided the fate of the Supreme Court's Practice and Procedure Act of 2023. This was a law passed in March which aimed to essentially do two things: regulate the Chief Justice's exercise of the suo motu power and also regulate the Chief Justice's administrative authority for forming benches and thus fixing cases. The third thing that the Supreme Court Practice and Procedure Act also aimed to do was to provide an appeal for all those cases that were decided in the court's jurisdiction of Article 184.3, which many consider the original jurisdiction's suo motu power. Now, what does suo motu mean? To break this down, it means of one's own motion, and it is linked directly to Article 184.3 of the Constitution, which says that the Supreme Court can take notice of any matter as long as it is a question of public importance with reference to the enforcement of fundamental rights. Now, this particular law was also passed in a certain context, but we'll come to that in a second. To first go through the short order that has been issued recently, we find that by a 10-5 majority, this was a full court, a full bench of the Supreme Court, by 10-5, the court has ruled that the committee, which is to decide the assignment of cases and the formation of benches, has been upheld and has been held to be legal. The next plank was a 9-6 majority in which the Supreme Court has also held that there is to be an appeal provided to cases decided under Article 184.3. And then finally, by a bare 8-7 majority, the Supreme Court has ruled against that appeal being provided retrospectively. So what this means is the committee, where 3 judges will get to decide the formation of benches and also get to decide whether or not to take suo motu notice or not, that is to say a majority of the 3-member committee, while they can also form a larger bench to hear the appeal that is going to be decided vis-a-vis those cases. The Supreme Court has still stopped an inch short of holding that retrospective decisions, that is to say judgments that have already been decided in the past under Article 184.3, those judgments can no longer be, or rather can still not be interfered with. Some high-profile cases that come to mind include Mia Nawaz Sharif's disqualification under Article 62(1)(f), and then also an ancillary judgment saying that the disqualification under Article 62(1)(f) is to be for life. Now, what this means is that there is a radically new way for the Supreme Court to be forming benches, to be assigning cases, and to also be exercising its suo motu jurisdiction. Prior, it was only the Chief Justice in his individual capacity. He was in fact deemed the master of the roster by a 5-member bench of the Supreme Court, and he was thereby empowered to exercise suo motu jurisdiction in his individual capacity. That power has been diffused by 3. So the Chief Justice and the 2 senior-most judges will now decide by majority whether or not to take suo motu notice or not, how to actually form benches, and how to allocate cases. So the controversy, or rather the questions that have arisen from such a dramatic change in the law, the first is the immediate context. This law was passed in the last week of March 2023, and the immediate backdrop was the Supreme Court having ruled on 1st March, which is to say the same month and just a few weeks prior, that provincial elections were to be held in 90 days in Punjab. So it was right after that that the then PDM regime decided to curtail the Chief Justice's powers, the primary power being the suo motu, the result of which was the judgment in which provincial polls were to be held in 90 days. Now, there is a very clear legal principle that malicious intention cannot be attributed to the legislature. And far be it from anyone to say that the parliament was being malintentioned in passing such a law. But it does beg the question that where the Supreme Court already has established jurisdictions in the Constitution, that is to say, the original jurisdiction, through which you take suo motu notice, the appellate jurisdiction through which an appeal is filed, and the advisory jurisdiction through which the President asks the Supreme Court a legal question on advice of the Prime Minister, how can a fresh jurisdiction be grafted on top of an existing jurisdiction? That is to say, if you are providing an appeal against a suo motu, you are creating a brand new jurisdiction and you are doing it without amending the Constitution. So we will have to see the detailed reasons of the majority judgment so as to find out how the Supreme Court has provided its reasoning for that one. As far as the principle of parliamentary sovereignty is concerned, many have said that this judgment is a step in the right direction for Parliament to say that it is competent and it has exercised its legislative rights. Now, in a parliamentary system like Pakistan, nobody can take exception to elected representatives deciding whatever they want to and changing whatever law they like. The question that arises is whether, when the Constitution says it can only be amended by 2/3 majority of the Houses of Parliament, could a law be pushed through that has such radical changes for the Constitution, for the judiciary, and for its original jurisdiction just through ordinary legislation? And finally, the other question that arises is, given that the judiciary was attempting to enforce elections in 90 days, and this law came on the heels of that judgment, whether it really is a win for the independence of the judiciary, given that other institutions remain as unregulated as they were on the first day. So these are questions that immediately arise, notwithstanding Justice Aisha Malik's very interesting question that if indeed an appeal is to be provided, then what would happen to those cases where the Supreme Court has already formed a full bench of 17 judges, or as we saw in this case, owing to 2 vacancies, 15 judges? How does an appeal lie against that, given that the same judges have already heard the case at full capacity, whereas the Supreme Court Practice and Procedure Act provides that only a larger bench can hear the appeal? What bench is larger than a full member bench? That is also something that the detailed judgment will have to tell us. But in broad strokes, it does seem that the independence of the judiciary, which was said to have been affirmed by this law, is very much in the woods. In fact, it would seem that in a very specific context, right after an electoral verdict, right after a verdict was passed down ordering that elections be held in 90 days, which goes to the core of our democracy, goes to the core of our federation, goes to the core of our parliamentary system, the former PDM regime attempted to curtail the Chief Justice's powers, and that curtailment has been upheld by a majority of the Supreme Court itself. Let's see what the detailed reasons say. Until then, I'm Asad Rahim Khan. This is Nevertheless.